welcome everybody. It's Marc Steiner right here on the Marc Steiner Show on the Real News Network. Good to have you back with us this week. And we really need to delve into, as we will today, the Supreme Court and the future of the United States under this new Supreme Court that is looming. One thing that people don't realize and think about is that between 1969 and 1992, the majority of appointments on the Supreme Court, 10 of them, were made by Republican presidents that replaced people who were nominated and put on the court by Democratic presidents. In that time, Bill Clinton and Barack Obama only appointed 4 justices. So there's been a trend. And think about this. If we take it back to the 30s, let's say, when then Franklin Delano Roosevelt, the president then, took on the Senate around expanding the Supreme Court, trying to make it a more liberal body, a more progressive body. He lost that battle, but he did begin the process of building a more progressive court that led to everything from Roe v. Wade in 1973, down to the issues of school integration in 1954, and major cases that affected the life and nature of our nation. So what's going to happen now? What turns? This liberal court I just talked about that Roosevelt created was really an aberration in some senses for America. Most of our courts have been conservative. Where will they go now? Well, I've asked a dear friend and colleague, somebody I know who knows many things in this area, to join us today. And we are joined by Michael Higginbotham, who is the Dean Joseph Curtis Professor of Law at the University of Baltimore School of Law. His latest book is Ghosted from Crow, and also Race Law, Cases, Commentary, and Questions that he wrote for law students. And Michael, welcome. Good to have you on the program.
Thanks a lot. Good to be here with you.
Always good to see you. So let's just jump into this in a very serious way. I mean, there were arguments being made during the election, of course, that the one reason, even if you didn't approve of everything Hillary Clinton stood for, was to vote for Hillary Clinton because of the Supreme Court. And many people poo-pooed that and said, oh, this is not so important. But clearly, now we're seeing what could happen when a moderate conservative, Justice Kennedy, decides to retire. There's a whole issue we can talk about on the side as well. Decides to retire and gives Trump a chance to appoint a new justice after Obama was denied that right by Senator McConnell, the majority leader. So where do you think this takes us?
Well, there's a whole lot there to talk about, and as you mentioned in your opening, the court has in fact changed from being a liberal court to being a conservative court over these last 40 or 50 years. Would you agree that being a liberal court was almost an aberration in the 200-odd years of America? Yes, I would, because most of the time the court has been a conservative court. The court has stood for preventing progress, particularly on areas of civil rights. I think about the Dred Scott decision. I think about Plessy versus Ferguson. Those were decisions that encaptured racial discrimination, encaptured racial oppression, rather than making it better. The aberration, though, would be Brown versus Board of Education. So occasionally the court made decisions that sort of led the country to racial progress rather than embrace the past. But I think you're correct that that was an aberration rather than something of the norm. Although Roosevelt did change that. And I think you saw that with decisions, particularly in the late 50s and 1960s, where you had the Warren Court, which was known as the most liberal court. Now, the fascinating aspect, though, when you look at conservative versus liberal court, and you think about the presidents that appointed these justices, many of the presidents are rolling over in their graves in the sense that they didn't think the justices would rule the way they did on many issues. Key example is, of course, Earl Warren.
Right,
who,
right.
Was
yeah,
appointed,
tell that story. People
Earl
realize,
Warren,
right,
appointed by Eisenhower.
A Republican president, obviously.
Republican president, not known for being a liberal at all, a very moderate to conservative president. So he appoints 2 individuals to the court, and when he's asked after his 8 years, two terms in office, did you make any mistakes while you were president? He said, I only made 2 mistakes in 8 years as president, and those 2 mistakes sit on the United States Supreme Court. He, of course, was talking about Earl Warren, who he appointed as Chief Justice, and Brennan, 2 of the most liberal justices. And so a lot of times people look back on that and they say, hey, we don't want to have that situation occur again. We don't want to have presidents appointing people who are making decisions that are inconsistent with the values of that particular president. And so I think that's what you're seeing lately. People refer to this phenomenon as getting suitored lately because of Justice David Souter and what happened with the Bush appointment of him. But people refer to that as, look, we have to be very careful as to who we put on the Supreme Court. We have to vet them very carefully. They have to have a long record because we don't want to be surprised by any of their decisions.
So let's take some of the things you just talked about. I mean, I add to that kind of court. The Warren Court, of course, had people like William O. Douglas on, who was probably one of my favorite justices in American history. And you also had Thurgood Marshall, later with President Johnson, appointing the first black justice and the great civil rights crusader himself. And then Justice Ginsburg and others who have been appointed since. So, but let's take a look at what we could be facing in terms of historical precedents for a moment. I often like to look about where we are now and compare that to the end of Reconstruction in 1887, when there was this kind of shining moment of American democracy in the South that tried to be built. It was resisted from the beginning, where terror took place against black folks and the white folks who were supporting this new multiracial democracy people were trying to build in the South. Didn't affect the North very much, but we're trying to build in the South. But that was crushed with Hayes's presidency. You saw the Supreme Court also becoming an activist court. You mentioned the cases like Plessy versus Ferguson that took place at that time, right? So talk a bit about theoretically what the power of the court could be to turn America backwards, what we could be seeing in terms of a political struggle because of this new court that could be taking place under Trump.
Well, what you bring up with the history of Reconstruction is something that I think is so important for people to understand, because we do have a divided power country. Our constitutional democracy is one where power is divided. It's always been that way, and hopefully it will continue to be that way in terms of three branches. You have the executive branch, you have the legislative branch, and you have the judicial branch. The genius of this division of power over the years has been that no one particular party has been able to control all three branches for a long period of time. So during Reconstruction, the Republican Party controlled those three branches for a long period of time. But it rarely occurred during the New Deal. Those branches were controlled by the Democratic Party for a long period of time. But it hasn't occurred very often. And so the division of power allows for much more participation between different parties in our government, which most people would say is a good thing. Now, the problem, of course, is when you have different parties participating and sharing in power, sometimes it's hard to get things done. And a lot of people say that, you know, democracy is not an easy process. It is a difficult process. But when you look at what's going on today, you have a Republican president, you have Congress being controlled by Republicans, both branches, and you have a Supreme Court, as you mentioned earlier, that a majority of members of the Supreme Court have been appointed by Republican presidents. So even though the court is supposed to be apolitical, that politics is not supposed to make a difference in terms of court decisions, justices are supposed to decide the law, not consider the will of the electorate, as representatives and the president are supposed to do. So the court is supposed to be apolitical. Many times it has not been.
Has it ever been apolitical? I mean, is there such a thing as not being a partisan on the court? I mean, it's a political place.
Well, it's interesting. It's interesting that you mention that, because it is a political body in the sense of confirmation processes. You have a president that's nominating. You have a Senate that's advising and consenting. But it's fascinating to look at what the court has done over the last 20 or 30 years when you consider that Republicans, presidents, have appointed most of the justices. There are, of course, over the last 20 years, swing justices. I think about Justice O'Connor. I think about Justice Blackmun. I think about Justice Kennedy, who of course has announced his resignation. Those justices, even though all three of them were appointed by Republican presidents, those justices sometimes have sided with the 4 justices appointed by Democratic presidents. And so what's interesting is oftentimes it happens that justices don't necessarily follow verbatim the values of the president that's appointing them. And so those 3 examples that I gave you of swing justices really reflect the importance of the court in maintaining the proper balance of power between all 3 branches.
But if you look at decisions made at the opinions of the justices that sit on the Supreme Court right now, and then you take whether it is issues around affirmative action, racial justice and education, the environment, Roe v. Wade, it seems that all those things
gay
that were
rights as well, you want to throw in here.
Right. Could be overturned, could be changed in a fundamental way, because these justices has really been very ideological in terms of what their rulings have been. And it's been that swing justice who once in a while in some of the cases has turned the other way. But we're looking at a court that could change everything people fought for over the last 40 or 50 years.
And Mark, that's why your question is so important, because this particular appointment could result in drastic changes of judicial decisions over the last 30 or 40 years. As you mentioned, affirmative action, most of the decisions have been 5-4. Gay rights, 5-4. Abortion, 5-4. Presidential power, 5-4. And so what you're looking at with this appointment is it could result in a major change, which is why it's so significant that the person that replaces Justice Kennedy be someone who is not necessarily going to automatically side simply with the viewpoints of the majority of the court or the viewpoint of the president that appointed.
So then, as a lawyer, as a constitutional law professor, as a historian of the Constitution and law and race in America, where do you think this takes us? I mean, what do you think we are facing, and how do we approach it?
Yeah. I think it's time for our legislative branch to step up. Many people suggest that they really haven't done their job over the last several decades in terms of standing up to presidential authority. So I think it's about time that they do. They have a constitutional role to advise and consent. The president has the power to nominate. And so we will see what happens in terms of advise and consent. I just heard one of our senators, Susan Collins, who is a Republican but viewed as a moderate, one who has taken a stand in terms of abortion rights. She has stated that a nomination of someone who is committed to overturning Roe versus Wade, or who has gone on record saying that they don't respect stare decisis and the opinions
Stare
of the
decisis
past,
being
respect for past Supreme Court decisions. Someone who has said they don't respect past Supreme Court decisions, Susan Collins said, I may have a problem in supporting that person. So in her role as advise and consent, she may say, no, I'm not going to consent. And that is the role that the Senate plays in this nomination process, a very important role, I might
So
add.
I wonder what you think it does for the political process and also the legal process in America, because a couple of things, I mean, as we conclude here. A, is that the federal justice system is being packed as well by Donald Trump during this era.
Unfortunately, that is
Right.
correct, yes.
So we're not just looking at the Supreme Court, I mean, the entire federal judicial system is being affected.
Yes, it
here
is.
with this presidency.
Judges, justices, federal judges or justices serve for life.
So some of the issues that have been fought, we've turned much of the political struggle in America into a legal struggle in the battlерooms inside of our courts, taking it to the Supreme Court. That could change the entire nature of how people fight for equal rights, for labor rights, for rights of black folks and communities of color, for the environment. I mean, this might change everything. I mean, when you look at the 60s, it was the political movement that forced Lyndon Johnson to pass the civil rights laws he passed in the mid-60s, and the Voting Rights Act. That wasn't done by the Supreme Court. That was a political act. This could change the entire dynamic of our country.
It could change it, and that's not necessarily a bad thing, because in our constitutional democracy, there are many ways to change our society. You can go to the president, you can go to the legislative branch, or you can go to the courts. And so, yes, sometimes during the civil rights movement in the 60s, there were appeals to the court. But other times there were appeals to the president and appeals to the legislative branch. So if you look at a lot of the things that were done during the civil rights movement in terms of going to President Johnson and saying, hey, we need a Voting Rights Act passed, the president and the Congress supported that. President proposed legislation, Congress passed that legislation, and the court upheld that legislation. So there are different avenues to make changes in our constitutional democracy, and when one avenue is closed, such as a conservative court to civil rights advances, then you go to other avenues. That's sort of the importance, I think, and the brilliance of our constitutional democracy. There are different ways that we can change society.
Now, I do my best not to be an oh, woe is me man person. And trying to think of the people who came before us and fought and didn't just say, okay, we're just going to lie down and take this and we're done. But I'm curious, having said that, what you see as the potential 21st century versions of Plessy, of Dred, of other cases that push things backwards, given everything we pushed forward through the courts and more. I mean, what are the things that concern you the most?
Sure. Tremendous concern about immigration these days. You know, President Trump has done a lot of horrific things when it comes to racial equality and justice. You know, I think about his statements in Charlottesville, embracing some of the white supremacists. I think about his statements during the campaign about Mexicans, immigrants being rapists. But when I looked at the separation of the children on the border, this recent policy that President Trump adopted, and then he blinked on it a little bit. We'll see what happens, though. But to me, that's one of our major civil rights battles in the 21st century. A just immigration system that recognizes people's rights and privileges and values in terms of coming to this country and being accorded asylum. I mean, we have treaties, we have a long history of supporting people's right to asylum, and so we've got to make sure that we do this consistent with that.
What happens to things like affirmative action, voting rights? I mean, we've already seen the diminishment of voting rights in America, and also Roe v. Wade and the pushing back, letting states outlaw abortion. I mean, there are battles being set up here by this new court.
There are battles being set up. There are a lot of risks. If Roe versus Wade is overturned, and not necessarily will it be, if you have a nominee. Right now, it's a 5-4 court, right. And if you have a nominee that goes against what Justice Kennedy said about abortion, then that may be at risk to have Roe overturned. If not, as you say, there may be flexibility in terms of what states can do to limit abortion, which would also be problematic. So that's a battlefront. The battle will occur if Roe is overturned, or if not overturned, if states are given a lot of leeway to restrict abortion. The battle will occur in state legislatures rather than in the Supreme Court. People will have to go to their state legislators and say, hey, we want abortion rights. We don't want you to limit to that extent, to the maximum extent you can do under federal law. So battles will occur in state legislatures rather than at the Supreme Court if you have a change in Roe versus Wade.
I'm going to look forward to having you come back often to kind of help us explore as this grows, and we see what happens in the U.S. Senate. We'll see what happens with the nominations, whether Democrats can hold it up, which I doubt, given the political process. But this is, I think, one of the most critical junctures we have, and I would say to all of us listening out here, This is a reason why I think all of us have to really think through what it means when you demonstrate, when you organize, when you vote, what we're looking for as a nation. We're at a precipice, and it can be ours. It just depends which way we want to take it.
I'd love to come back, and I think it's time now for good Republicans to stand up as well.
Amen to that. So we're here with F. Michael Higginbotham, who is the Dean Joseph Curtis Professor of Law at the University of Baltimore School of Law, who has written numerous books, including Ghosts of Jim Crow, which is a really good book that I read a while back, and you should read it yourself. And Michael, good to have you in the studio. Thank you so much for joining us.
My pleasure.
And I'm Marc Steiner for the Real News Network and the Marc Steiner Show right here, saying thank you for watching, and we'll check in together next week.